I'm back. I told you I had a busy trial schedule coming up over the next couple months. Well, we have a great show for you. There is some last-minute legal maneuvering in the Lori Vallow upcoming trial. Sam Bankman-Freid is a scumbag. I will explain. Alec Baldwin scores another win in his case in New Mexico. And Alec Murdaugh may have actually helped his friend get a new trial. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for watching. You know the drill. Subscribe if you haven't. Hit that like button if you do. Leave me a comment and hit that little bell for notifications. And remember, you can listen to this podcast as well as anything in our previous library anytime on any of your favorite podcasting apps. All right. We also, before we get started, have to support the people that support us. And yes, Baked in Colorado, they've been a sponsor here. And guess what? They had some supply chain issues, but those have been resolved. And so now it's time to get your CBD dog treats and the beverage enhancers. Now, these are no ordinary dog treats or beverage enhancers. No, this is all the good stuff, the CBD, all the good stuff from the hemp without any of the high. That's right. You don't want your dog getting high. But these treats, they are going to help you with your dog. They've got hip and joint issues, reduce anxiety, improve skin condition, help with inflammation, and aids in digestion. So go to the link, get your dog treats, beverage enhancer, get signed up, and it'll get shipped out to you the very next day. And guess what? You can sign up and get that subscription going so that you can always have your dog's favorite dog treats available. Your dog is going to love it and to be happy that you did it for him. All right, let's get started. Yes, I've been gone for a couple of days. I'm telling you, I used to do literally a trial once a month, and then COVID hit, and we did maybe 3 over the course of the entire COVID period, which is probably 3 more than most attorneys that I know. Anyway, we just had a schedule packed with trials lately. And, well, that's where I was the last 3 days. It turned out better than expected, but we will just leave it at that. So sorry I missed getting a regular show up. Sorry I missed Patreon. I hope to make it all up to our Patreons next Tuesday night. All right, let's go ahead and do the docket for March 16th, 2023. Please open the record. That's right. Preparations are underway at the Ada County Courthouse for the trial against Lori Vallow. That's right. The mom accused of conspiring to kill her 2 children, JJ and Ty Lee, and also conspiring to kill her 5th husband's previous wife, Tammy Daybell. That trial is supposed to begin April 3rd. It's going to be good. Now, we here at Crime Talk, since Judge Boyce has decided that anyone that's not immediately in the courtroom is too stupid to conduct themselves in an appropriate manner, that there will not be a televised or recorded proceedings. However, audio is going to be made available. We are working on getting that and bringing it to you, but I don't think it's going to be live, but we're going to see what we can work out. Anyway, if we can make it happen, we're going to bring it to you. So what's going to take place? Well, potential jurors are going to answer questionnaires at the courthouse beginning on March 27th and 28th. Now, the prosecuting attorneys and the defense counsel will be permitted to observe the jurors filling out their questionnaires. Now, that's not that big of a deal, right? Jurors show up, they get a packet, they answer the questions to the best of their ability. Then the court will take those questionnaires, hand them to the attorneys after they've been photocopied for each side. One will be made a part of the official record. Then the attorneys will go through those questionnaires and see if there's something in any of those answers that would automatically exclude somebody being a juror for what they call cause. Basically, they cannot be fair and impartial to one side in the proceedings. In fact, I can tell you, in the trial I just did, in one of the juror questionnaires, the juror was firmly convinced that the defendant had to prove themselves innocent. Ooh, blew everybody's mind, and that particular juror stuck with that analysis throughout. Needless to say, that juror didn't sit on the jury. So those are the types of answers that they're looking for. And you will be surprised what people will say when they fill out their questionnaires. I've had people say in their questionnaires, I can't do this. I am prejudiced in one way or another. I hate all people. They hate people of particular ancestry. You name it. They will come up with anything to get out of jury service. And guess what? Usually the attorneys in the court will agree, get them out of here. They're bringing in hundreds of jurors for this particular case. I assure you they're going to be able to whittle it down. And my guess is there's going to even be a few people that have not heard a single thing about this particular case. I guess it was a good thing that the judge kept everything so secret. Yeah, no, not really. Anyway, so the voir dire process, that's the jury selection process. It's a French word to speak the truth. I know someone's going to say, no, it really translates to this. Well, that's what it means in the legal system, okay? Anyway, that's the process begins, and there's going to be limited public access to the simulcast remote viewing rooms at the Ada County Courthouse as well as the Madison County Courthouse for the voir dire process. That's the jury selection process. Family members obviously have priority seating, which that is fair and should be that way. And the remaining seating will be assigned through a reservation system at the Ada County Courthouse. So get your reservations now. You know how you hate waiting for a table for dinner. Could you imagine waiting on a seat to watch the trial? Yeah, get your reservations in now. Now, some portions of the jury selection process will be simulcast. Those are the questions that are going to be asked to the general panel when they're in the courtroom. If there is a need for individual voir dire of a potential juror, then that's will not be made available to the public. Now, you may say, Scott, why can't you just do it all in public? 99% of all the questions in a jury selection process can be done in open public. It's simply to see if you're a fair and impartial juror, and if you're not, get rid of you. Now, nobody in the court system wants to embarrass somebody if they have been a victim, if there's something truly emotional that they find embarrassing that they don't want to do. And guess what? You have the person go and approach the bench. Sometimes it's in chambers, but you have the court reporter, the defendant, both the counsel, and the judge there. And they explain, hey, maybe this just isn't the right case for me. I was a victim of this. I'm really traumatized by it. I'm embarrassed by it. Boom, get him out of there. I do not see why or how this should take so long. The big issue here that everybody seems to be speculating about is religion going to be a big area that prospective jurors focus upon. I don't know. I don't really see what it says. If somebody says, hey, I can follow the law that the judge gives me if I'm selected, I can listen to the evidence and base my decision based upon legal and competent evidence that comes in through people's testimony and exhibits that are properly admitted, and I'm going to make those decisions as to whether there's guilt or innocence after all the evidence is presented, reserving judgment till it's all presented and there's final deliberations. I don't see what it matters what religious affiliation somebody has in a particular case, unless that juror volunteers and says, hey, I'm a member of the LDS church, and I'm either going to find them not guilty because of that, or I'm going to find them guilty because they made the church look bad. Guess what? It really doesn't matter. I cannot think of a single time, except maybe when I represented a former priest, that religion ever came up in a criminal trial. It should have no bearing on anything. So, as I said, we had lots of news on the Lori Vallow matter. There was a hearing yesterday, and it was kind of a rehash of the motions filed by Jim Archibald and John Davis, who are Lori Vallow's attorneys. But let's go through the motions that were argued. Now, the first one was a motion to compel, filed by Chad Daybell's attorney, asked for the prosecution to turn over all written and recorded statements made by Chad while he was in custody. Seems fair, right? Guess what? The attorneys for Lori Vallow said, yeah, I guess we just happened to receive 3,000 phone calls and recordings of 5 in-custody visits involving Chad Daybell. They received them on Monday. Now, here's the problem, okay? We're a couple of weeks away from beginning trial, and the prosecution, who's had all of this information, is just now turning it over. Big problem. And all the prosecution, Miss Lindsay Blake, who I think this is her first death penalty case. I think it's probably one of her first ever large trials. Well, she is confident that all previously recorded conversations have now been turned over to Lori Vallow's defense team. And Lori Vallow's defense team acknowledged that they did receive these 3,000 phone calls and the 5 in-custody visits from Chad Daybell on Monday. Now, he didn't specify as to who Chad was speaking with or visiting when these calls were made, and obviously what the subject matter is, but you don't know. And listen, one of the worst things that you can ever have to do as an attorney or have an investigator do it or a paralegal is listening to jailhouse calls. Why? Because everyone has to be listened to. They have to be indexed. You have to know what was said on there. You have to be able to give it context. Some of the worst things I've ever heard have been on jailhouse calls. I've heard people literally passing kidneys on jailhouse calls. I've heard people confess. I've heard people break down and cry like little babies when they're supposed to be tough guys. You just never know what's going to be said on those phone calls. Why the prosecution hasn't turned those over is beyond me. They didn't just happen to have 3,000 phone calls, which happened in the last 30 days. No, that's over the last 3 years. Why is the prosecution playing games? I don't know. Why? They should have been turned over early. Next, a motion in limine was argued. What's a motion in limine? It's a fancy word for the court to exclude certain evidence from coming into trial. So Lori Vallow's attorneys asked the judge to exclude evidence, basically anything that the prosecution has disclosed after February 27th at approximately 4:07 p.m. Why? Because Judge Boyce ordered on December 27th that all evidence must be submitted prior to February 27th. And anything after that won't be permitted to be used by the prosecution. Wonder how the prosecution feels about playing games now. Yeah, not good. Mr. Archibald argued at the hearing that a lot of these late disclosures contained a lot of data, and it was late, and it should have been produced a lot earlier. Specifically, Mr. Archibald argues to the dump of some 5,000 pages that were dumped on that on February 27th, hours of videos and audio recordings, another 3,000 phone calls just 2 days ago. And he says it's a little disappointing that we had to wait this long to get all of the discovery. I totally agree. And the Madison County prosecuting attorney, Rob Wood, who handled this particular motion, responded by saying the amount of evidence in this case is so voluminous and the prosecutors have never intentionally not turned anything over to the defense. And he said many of the reports contained in the recent filings were given to Daybell's attorney back in August of 2021. That time, Ms. Vallow's attorney was Mark Means, not Mr. Archibald or Thomas. And so the prosecution says, we do not believe that it was late disclosure. We believe that the February 27th deadline was met, and the state has always endeavored to disclose what we have. Now, let's be fair. When the new attorney entered, the new attorney should have got all of the discovery. The prosecutors should have had a system in place to make sure this doesn't happen. And our prosecutors, where I practice, they've got it pretty good. They can tell you every page is numbered. It gets sent to you in various batch downloads that you have these days. And frankly, it's eliminated a lot of trouble that you used to have when it was old paper discovery and an occasional disc. It's all digital these days. The prosecutors in the Vallow Daybell matter need to get their act together. And then finally, there was a motion to dismiss the death penalty. Now, this was kind of a rehash of the previous motions that had been discussed, but Mr. Archibald argued that due to the cumulative error, the death penalty should be dismissed, in this case against Ms. Vallow, and that they listed all their reasons why. First, media saturation, multiple violations by the government's knowledge of his client's mental health issues and the practical standpoint that the state of Idaho has been trying to kill people on death row, and frankly, they failed miserably at it, and they can't kill anybody because there are no chemicals to kill anybody with. And he also argued that since his team just received this large amount of discovery so close to trial, that his mitigation specialists cannot adequately do their job. And I'll go into that in just a minute. So the mitigation specialist gathers detailed background information about the defendant in order to persuade a jury not to impose the death penalty. And they argued that they don't have time to go back and now review 3,000 phone calls and 5,000 pages of what was dumped on them back on February 27th. And they say that their mitigation specialist, who has worked on death penalty cases for almost 40 years, says this is a big problem. And this is going to be a disaster on appeal because right now, Mr. Archibald states that he and Mr. Thomas are telling the court they are not enough hours between now and trial to review all of this evidence. And now in their written reply, Mr. Archibald laid out his argument much more clearly than he did in court. And here it is. I think it's worth noting. The state is running a cost-benefit analysis on the Lori Daybell case. If they wait to disclose information at the last second, it will likely be considered harmless error because the burden is on the defense to show that the late disclosure would have likely changed the outcome of the case. The cost-benefit analysis here cannot be measured by dollars and cents, as the Ford Motor Company did when they ran the analysis of changing the gas tank configuration on the Ford Pinto. The justice system should not and cannot allow the government to prosecute this case like a corporation. The cost is too high and the potential for error is too great. The government's arguments of substantial compliance and potential existence should be summarily dismissed. The fact that the prosecutors put the defense on notice that this information potentially existed somehow then shifts the burden from the prosecutor to the defense in violating Ms. Vallow's constitutional rights to due process under the 5th and 14th Amendment and violates fundamental fairness, like the substantial compliance argument shifts the burden from the government to the citizen in violation of the constitutionally protected rights of the due process and fundamental fairness. It says that the state of Idaho has spent well over $3 million in the prosecution of this case so far, and that money was spent on personnel, police, prosecutors, investigators. And for what? Substantial compliance? For $3 million, the government should be at complete and total compliance. We don't have a breakdown of the actual dollars and cents spent on getting the discovery to the defense, but I can almost guarantee that it is but a sliver of the $3 million price tag. Yes. Goes on, the government's argument seems to put the burden on the defense to compel information that it thinks the government might have in violation of criminal rules without knowledge thereof. The government knows what evidence they have against the defendants. They are in the best position to turn over what evidence they have. This includes the evidence against any co-defendants. Now, Ms. Blake's argument is that filing a motion to dismiss the death penalty is premature, as trial has not been held yet, and that Ms. Vallow has not yet been convicted and sentenced. And as the court will recall, defendant Lori Vallow asked for a bill of particulars in this matter. We asked the government to disclose several things like who the other co-conspirators were, as part of the argument that the defendant stated. The discovery in this case is voluminous, to say the least. The discovery is still ongoing, and as the date of this motion, the defense has nearly 5 terabytes of electronic material. Much of the discovery has been gathered over several years, and the defense is in the position of sorting through all of the discovery, which the prosecution has had, in some instances, for years. And then they cite to the bill of particulars. Now, Mrs. Vallow further reasoned that the bill of particulars would help to avoid any unfair surprise. It's also a need to avoid unfair surprise at trial, a further purpose of the bill of particulars. And under the current indictment, the government could change the theory under motion for bill of particulars, which is alleging murder or conspiracy at its whim between now and the trial or during the trial itself, posing a grave danger of unfair surprise. And finally, the prosecutors are pursuing the highest, most final, harshest penalty allowed in the country, and the defendant should have the right to defend herself and face her accusers armed with the information needed to confront the government's allegations. That's right. The government filed those motions, the bill of particulars, back in September of 2022. And the government's response was the motions were a thinly veiled effort to obtain the state's trial theory and work product prohibited under the rules. The government was obviously aware of the duties under the Idaho Rules of Criminal Disclosure to disclose evidence as requested by the defendant. They were using the rules of surgical precision to avoid having disclosed information about their case. The court took the motions under advisement and issues decisions during a Fremont County hearing back in March of 2022. Now, of course, the Judge Boyce, like all judges, he's concerned. He's concerned that these issues are now just being dealt with so close and early to trial. Well, one could argue that perhaps the judge's lack of control of this case, not imposing strict deadlines for the prosecution to comply with, could have led to this exact and very thing. So what does it come down to? It comes down to what I have said over the years. Go back and look at past episodes if you don't believe me. But I'm telling you, a good prosecutor will tell you, I will get you everything you want. You need in discovery. I will double check every nook and cranny to make sure it's being turned over. And guess what? I'm still going to convict your defendant. Always be careful of district attorneys that play games with discovery. It means either one, they're not confident of their case, or they're not confident in their abilities, or both. These prosecutors are playing games. This case is theirs to lose, and they'll probably get a conviction. Let's be realistic here, but it's not for a lack of trying. They have been trying to screw this case up from the beginning, and if they do screw it up, it's all on the prosecutors. They are, and I hate to say it because I like Rob Wood early on, but I hope they change my mind, but it's really starting to seem like amateur hour here in Idaho when it comes to the Lori Vallow case. Now, one thing I want to talk about as well is the mitigation specialist. There was an affidavit or declaration by the mitigation specialist that was filed for the defense. And this particular mitigation specialist has been doing this for over 40 years and has worked on at least 120 death penalty cases. And I think some of the information is kind of relevant, and it goes to the fact that the way this case is played out, and I blame the prosecution, I blame the judge, and the defense somewhat. Obviously, the defendant created the facts that have put us all here together. Let's be realistic. But the prosecution could have waited to file this case when they were ready. They piecemealed it, and frankly, it looks like it's being put together by a bunch of hodgepodge of information held together maybe by a little bit of duct tape. I hope they get their act together. Let's just be clear about that. Anyway, the mitigation specialist says, hey, I'm trying to comply with the ABA guidelines here because this has ineffective assistance of counsel written all over it. When you dump some 5,000 pages of discovery on the defense at such a last minute, you can't do it and you can't be effective. So the mitigation specialist, like I said, I'm not going to go through the entire 20-paragraph and 8-page declaration, but it basically says that the ABA standards enumerated the minimal resources and practices necessary to provide effective assistance to counsel. The guidelines state that in the commentary that the lawyer has a substantial and important role to perform in raising mitigation factors both to the prosecution initially and to the court at sentencing. Investigation is essential to fulfilling these functions. It goes on. Lawyers are generally unprepared and ill-equipped to discover mitigation evidence without expert assistance. The special skills and abilities necessary to obtain sensitive and sometimes embarrassing evidence about a client's life experiences from family members and other sources are often beyond the abilities of even the most skilled courtroom lawyer. Totally agree. And she states, I have conducted a mitigation investigation on the background of Lori Noreen Vallow to the extent possible given the time constraints in accordance with my duties as a mitigation specialist in this case. I have determined that a significant amount of important information, both in the form of documents and witnesses exist. In addition to the available information are leads of unknown origin that would undoubtedly come up as a team pursues the information we have uncovered or learned of through the discovery already provided in this case. The discovery in this case exceeds 4 terabytes. This is an incredible amount of information, some of which has only recently been given to the Vallow defense team just prior to the discovery cutoff and afterwards. The state, along with their cadre of law enforcement officials, has had this information possibly for 3 years prior to the defense team beginning their work in the late spring of 2022. Sifting through such a large number of investigative documents, audio and video files, and metadata and other specific evidence, determine how each piece of information applies to either the fact or mitigation or both sides of the defense case is a very time-consuming job. There's absolutely no time to begin investigating new information after determining how it relates to the mitigation case. I must admit, because of the client's insistence on maintaining their speedy trial rights, I have not been able to completely review the discovery we have already had. The recent disclosures make reviewing the complete discovery, frankly, impossible, and the recent addition of numerous witnesses listed without identifying information or a summary of what their testimony would be at a later date constitutes a gross miscarriage of justice, and even the state must admit the defense cannot begin to investigate this new information on the eve of trial. Basically, what they're saying is, let's go do this trial, and then let's come back in the next 5 years, and we're going to do it all over again. And yes, the defendant has the right to a speedy trial. She can waive that right to a speedy trial, but she doesn't have to. And the fact that the prosecution has had a case for 3 years and they're just now dumping tons of discovery on the defense, it's unacceptable. It is unacceptable. I'm just saying that. Yes, I'm going to say I'm a little biased because I think the prosecutors and good prosecutors do this. They give you everything. They don't play games. And I don't know if it's gamesmanship on the part of the prosecution or if it is incompetence. I guess only time will tell. But once again, if the prosecution loses this case, it's on them. If this case comes back on appeal or later on post-conviction relief for ineffective assistance of counsel, the prosecution needs to look to themselves and say, wow, I guess we could have done things a whole lot differently. Next on the docket, Sam Bankman-Freid. He's a scumbag. So according to some bankruptcy court filings, Sam Bankman-Freid has secretly transferred, roughly $2.2 billion from FTX to his personal account and another $1 billion to 5 members of his inner circle just before that cryptocurrency exchange collapsed. Now, Mr. Bankman-Freid and his 5 friends transferred a total of $3.2 billion in total to their personal accounts as payments and loans, using funds primarily coming from Alameda Research, the crypto trading hedge fund affiliated with FTX. And according to the financial statements filed with the bankruptcy court in Delaware, Mr. Bankman-Freid is in a lot of hot water. He currently faces several federal charges related to the FTX collapse and is obviously accused of looting the platform for his own personal gain, and not to mention a bunch of securities fraud. Of course, he's pled not guilty, and he is being detained, if you really want to call it that, basically house arrest, but he's free. He gets to sleep in his own bed. He gets to eat prepared food. He gets to have his friends come. He gets to play on his computer and move things around, which everybody knows that he's doing, but nobody seems to want to call him out on it. He's at home for now. We'll see how that works out. His trial begins in October. This is one of those trials. Let's get it over with. Let's get it done. And not including the $3.2 billion that he's accused of taking are roughly another $240 million in luxury property in the Bahamas. He also gave a bunch of money of that $240 million to political and charitable donations and substantial transfers to subsidiaries, according to FTX's management. Now, 3 FTX insiders, Nishad Singh, Gary Wang, and Caroline Ellison, have previously pled guilty and are cooperating with prosecutors. They transferred more than $800 million to themselves, according to FTX. And Ellison is the former head of the Alameda hedge fund who received $6 million and told prosecutors that she had access to an unlimited line of credit from FTX. Hey, I think as we're all seeing, it's just not really money. The banks going under. It's not real. Nobody cares. Now, thank goodness, nobody on the crypto side was bailed out. And unfortunately, they bailed out everybody out there at the Silicon Valley Bank last week. You know, normally it's $250,000 per account, but don't worry. I guess if you're a rich millionaire hedge fund, you can don't have anything to worry about, because, we can't have rich people losing their money, because if you turn rich people into poor people, can't have that now, can we? Next on the docket, Alec Baldwin wins again in his case in New Mexico. The special prosecutor in the case against Alec Baldwin and the whole Rust shooting regarding the cinematographer back in October 21 has announced that she is stepping aside. That's right. That's a big victory for Alec Baldwin. Why? Well, Andrea Reeb was elected in November to the New Mexico House of Representatives, and Baldwin's lawyers argued that she was therefore ineligible to continue as a special prosecutor. Now, Reeb investigated the shooting on behalf of the Santa Fe District Attorney's Office and concluded that Baldwin and his team, a producer of the film and its star, were responsible for the death of Helena Hutchinson. And in her parting statement, Reeb reiterated those views. Quote, "It was becoming clear that the best way I can ensure justice is served in this case is to step down so that the prosecution can focus on the evidence and the facts, which clearly show a complete disregard for basic safety protocols, which led to the death of Helena Hutchins. I will not allow questions about my serving as a legislator and prosecutor to cloud the real issues at hand." End quote. Baldwin's attorney filed a motion to have Reeb removed from the case because of her position in the legislature, basically arguing that you can't serve as a special prosecutor when you're a member of the third branch of government, another branch of the government. The defense attorneys argued that her serving as special prosecutor was unconstitutional, and they argued that she must be disqualified. Specifically, they pointed to Section 1 of Article 3 of the New Mexico Constitution, noting that it states that a sitting member of the legislature may not exercise any powers properly belonging to either the executive or the judicial branch. Obviously, the prosecutors are a representative of the executive branch, and therefore she had to go. I guess my hat's off to her. Since she said it's not worth the fight, somebody else can step in. Now, you have to also remember that it was Ms. Reeb that filed the sentencing enhancer in Mr. Baldwin's case that would have made it a mandatory 5 years in prison. Unfortunately, like lots of legislators and prosecutors, they didn't read the fine print that said it didn't go into effect until after the date of the incident. So therefore, that went away. Now, as you may recall, Mr. Baldwin has stated the shooting was not his fault because he trusted those on the set to make sure that the weapon was not loaded. We'll keep you updated on that. I think they should just cut to the chase, offer him a misdemeanor or some sort of deferred judgment, probation, and a bunch of useful public service in New Mexico. That's probably what's going to turn out. Anyway, let's go. Next, Alec Murdaugh's friend wants a new trial. That's right. Remember the former CEO of the Palmetto State Bank and his alleged notorious accomplice of being that of Alec Murdaugh, the now convicted killer? Well, he put in a new motion for a new trial citing Alec Murdaugh, his friend, specifically his court testimony, said that it vindicates him of all of the alleged crimes that he was ultimately convicted of. So Russell Laffitte was convicted in November of 2022 on 6 financial crimes related to a decade-long alleged corruption scheme led by Alec Murdaugh, in which hundreds of thousands of dollars were laundered from clients. Mr. Laffitte was denied a new trial by a South Carolina district court judge in the federal jurisdiction there for South Carolina on March 6th, but said the testimony from Murdaugh's trial, in which he was convicted of the slayings of Maggie and Paul, should and need to be considered. Specifically, on February 23rd of that trial, Mr. Alec Murdaugh explicitly stated for the first time in sworn testimony that he did not participate in a conspiracy with Mr. Laffitte because Mr. Laffitte did not participate in the financial crimes. Mr. Murdaugh took full responsibility for his own actions and testified that Mr. Laffitte did nothing wrong and did not have any knowledge of Mr. Murdaugh's criminal activity. Mr. Laffitte now did collect $392,000 in fees for those 6 clients of a personal injury attorney at a law firm in Hampton, South Carolina, according to the press release by the United States Attorney's Office. Lafitte then allegedly transferred personal loans to himself and to Mr. Murdaugh from those accounts and used the funds for personal expenses, according to the prosecutors. Now, the motion gave specific quotes from Mr. Murdaugh on the stand. He said, quote, "I don't dispute any of that. I took the money. That didn't belong to me. That I misled people that trusted me to do that. What I did was terrible. I don't dispute that," Mr. Murdaugh said. He said also, "You keep talking about stuff I did with Russell Lafitte, but I want to let you know is that I did this, and I'm the one that took people's money that I shouldn't have taken. Russell Lafitte was not involved in helping me do that knowingly. He did it. He did it without knowing it." Lafitte, who was standing trial in November for several of those charges, was found guilty in Charleston after more than 11 hours of deliberation and actual dismissal of 2 jurors during deliberation. We'll see. You know, when you go down on murder, you can say lots of things. He was probably trying to help his friend out. If you believe him that he was being truthful, then you have to believe it. If you think Mr. Alec Murdaugh was lying that day, you say, he's just lying to help his friend out, because that's what he does. Lie. And finally today, our dumb criminal of the day. A 39-year-old woman is facing a felony battery charge for allegedly striking her 68-year-old boyfriend in the eye with, yes, that's right, guess the food, an avocado. More food violence. Carlene Biswanger and the victim have been living together in St. Petersburg, Florida, in an apartment for about the last year. Police allege that Miss Biswanger threw an avocado at the victim's face, causing injury to his right eye. Biswanger also allegedly threw a hanging rod that struck the man in the arm. At least it wasn't a food violence. Anyway, a portion of the incident was witnessed by a neighbor. The alleged battery occurred at an apartment complex for residents aged 62 years and older. And after being read her rights when she was placed in custody, Ms. Biswanger denied directly striking the victim. Biswanger was arrested for battery of a victim aged 65 or older, which makes it a felony. She was released from the county jail on bond Sunday night. Obviously, she can't go back to the apartment where she could undoubtedly throw more avocados. Ms. Biswanger, you are a dumb criminal of the day. Food violence. It must stop. We're calling you all out now. Stop the food violence. Stop the food violence, ladies and gentlemen. I think the whole world has lost their mind anyway. And I know maybe it's a little idealistic, but violence is not the answer. Unless, of course, you've tried everything else. But somehow I don't think Ms. Biswanger had tried everything else. Anyway, thanks for watching. Once again, I apologize for not being here earlier in the week. This damn day job keeps getting in the way of doing the fun stuff. Anyway, thanks for watching, and we'll see you next time on Crime Talk.